want you to picture something simple. A creek. Clear, cold water running over smooth stones, cutting through a valley the way it's cut through that same valley for 10,000 years. Now picture a chain link fence built right across it, bolted into concrete footings, with a padlocked gate in the middle and a laminated sign zip tied to the wire that says private property, HOA members only. That's what I found on a Tuesday morning last spring, standing in rubber boots on land my family has worked for 3 generations. A water right. By the end of this story, that fence would be gone. The HOA that built it would be facing state fines, a class action from 6 ranching families, and a board president who would resign in disgrace at a public hearing with 40 angry neighbors watching. But on that Tuesday morning, all I knew was that my creek, water that 6 families depended on to survive, had stopped flowing. The paper that matters. Out here, in most of the western United States, water doesn't automatically belong to whoever's land it happens to be sitting on or flowing through. Instead, most states use something called prior appropriation, basically, first in time, first in right. Whoever first put the water to what's called beneficial use, irrigation, livestock, drinking water, and had that use legally recorded, holds the senior claim. Everyone who comes along later has to respect that senior claim before they can touch a drop, no matter who technically owns the ground the creek runs across. It started small. The flow dropped a little more than seasonal drawdown would explain. Then, one week in April, it dropped by almost half overnight. I drove up along the access easement, a right-of-way my family has held for 60 years specifically to inspect and maintain the creek and diversion structures, and that's when I found it. A fence. Chain link, about 6 feet high, running straight across the creek bed and up both banks, tied into new concrete piers. On the upstream side, past the fence, I could see they'd built some kind of retention feature. A small dam, really, diverting a portion of the flow into a decorative pond near the new clubhouse. There was a sign. HOA members only. I want to be clear about something. I didn't march up there swinging a tire iron. I'm not that guy, and this isn't that kind of story. I drove to the little sales office they'd set up near the entrance and asked, politely, to speak with someone from the HOA board. That's how I met Marcus Doyle. Marcus was the HOA board president, a retired commercial real estate developer, sharpshoot even on a Tuesday, the kind of handshake that's a little too firm because he wants you to know he's the one in charge. I explained who I was, showed him a photocopy of our water rights certificate right there in the parking lot, and asked him, calmly, why there was a fence and a diversion structure across a creek that my family held senior rights to. He smiled at me like I'd told a joke he didn't find funny. That's HOA common property, he said. The creek runs through our development. We've got a landscape architect who designed that water feature. I'm sure whatever old paperwork you've got, our attorneys can sort out with your attorneys. I told him it wasn't a matter of paperwork sorting itself out. It was state law, and Downstream users, including 5 other ranching families besides me, needed that water flowing, especially heading into summer. He told me to have a nice day and walked back inside. Chapter 3. Trying it the easy way. I want to give you the timeline here because I think it matters. This wasn't a story where I went nuclear on day 1. I spent the next 3 weeks trying to do this the boring, patient way, because that's usually the right way, and because lawyers are expensive and I had hayfields to water. I sent Marcus Doyle a certified letter with a full copy of our water rights certificate, the original 1961 adjudication, and a formal request that the HOA remove the obstruction and restore natural flow within 14 days, citing the relevant state water code sections about interference with a senior appropriative right. I got a response 2 weeks later, not from Marcus, but from a law firm representing Aspen Ridge Estates HOA. 3 pages, very polished, essentially saying the creek crossing was on land the HOA legally owned in fee simple, that the water feature had been permitted through the county planning department as part of the development's landscaping plan, and that any pre-existing water rights I believed I held were a private property matter to be litigated separately, and did not obligate the HOA to alter improvements already approved and constructed. Translation: we own the ground, we got a permit for landscaping, and your 60-year-old water right is your problem, not ours. Here's the thing they got wrong, and it's worth explaining because it's the hinge this whole story turns on. Owning the land the creek runs through does not give you the right to obstruct or divert the water if someone else holds a senior water right to that flow. Those are 2 completely separate legal concepts, real property and water rights, and in prior appropriation states, the water right can absolutely override what a landowner thinks they're free to do with a stream crossing their property. A county planning permit for landscaping covers zoning and land use. It does not, and cannot, override state water law or extinguish a recorded senior appropriative right. No county planner has the authority to grant that. Marcus Doyle's lawyers either didn't know that, or were hoping I didn't. I called the other 5 downstream ranching families that week. Everyone had noticed the drop in flow. 2 had already started rationing water to their stock ponds. None had known, until my call, exactly why. Building the case. I hired a water rights attorney named Elena Cross, recommended by an old family friend who'd used her in a boundary dispute years back. She specialized almost entirely in appropriative water law, which turned out to matter a great deal, because this isn't the kind of law most general practice attorneys deal with regularly. The first thing Elena did was pull the full certified history of our water right from the state engineer's office, the original adjudication decree, amendments, and an unbroken chain of ownership down through my family to me. She also pulled the priority date, which mattered enormously, 1961. Aspen Ridge Estates, as a legal entity, didn't exist until 18 months ago. Their claim to common property over the creek, even if valid for the streambed itself, came more than 60 years after mine for the water flowing through it. Second, she filed a formal complaint with the state's Division of Water Resources, documenting the obstruction, the unauthorized diversion into the decorative pond, and the measurable drop in downstream flow, supported by flow gauge readings I'd started taking daily with a simple staff gauge I installed myself, plus historical flow data from a state monitoring station 4 miles upstream that had existed for over 20 years. Third, and this really got things moving, she pointed out that building a dam-like retention structure across a natural watercourse, even a small decorative one, typically requires a separate state dam safety and stream alteration permit, entirely apart from any county landscaping approval. She requested records of that permit from the state. There wasn't one. They'd never applied for it. The drone footage. While Elena worked the legal side, I worked the evidence side, because a picture, or in this case, aerial video, does more convincing in 30 seconds than a stack of documents does in 30 minutes. I borrowed a drone from my nephew and flew it up along the creek corridor on a clear morning in May. What I got was about 11 minutes of footage that told the whole story without a word of narration needed. I flew the same route 4 more times over the following 3 weeks, same time of day, documenting the same pattern. It became some of the clearest, most undeniable evidence in the entire case. I also kept a written log, dates, flow readings, photographs from the same fixed points on the bank, time-stamped. Elena told me that kind of consistent, boring, methodical documentation is often what actually wins these cases, far more than any single dramatic piece of evidence. Judges and state investigators trust a pattern more than a moment. The state gets involved. About 5 weeks after I first found that fence, an investigator from the State Division of Water Resources drove out and met me at the diversion point. Her name was Patricia Nguyen, and she'd clearly done this before. Measured tape, calibrated flow meter, camera, a folder of our file documents already printed and tabbed. She confirmed what Elena and I had already documented. The HOA's retention structure was diverting an estimated 18% of natural streamflow at that point in the season, without any state permit, directly interfering with a recorded senior water right. She noted the chain link fence itself wasn't necessarily illegal on its own. A property owner can fence their own land, but the moment that fence tied into structures altering the natural flow of the creek, and the moment it physically blocked the access easement my family held for inspection and maintenance of the diversion works downstream, it became a legal problem on 2 separate fronts. She issued a formal notice of violation to Aspen Ridge Estates HOA. 30 days to remove the unpermitted diversion structure and restore natural flow, or face escalating daily fines and a potential order requiring immediate emergency removal at the HOA's expense. I'll be honest, that was the first moment in this whole thing where I let myself feel some relief. Not victory yet, but relief. Marcus Doyle's last stand. Here's where it got interesting, because Marcus Doyle did not take that notice well. Instead of quietly complying, he called an emergency HOA meeting, open to residents, which meant I was legally allowed to attend, and I did, along with Elena. About 60 homeowners packed into the clubhouse. Marcus stood up front with a printed presentation, and I'll give him credit, he was a confident speaker. He told the room an outside rancher was trying to shut down their beautiful community water feature over decades-old paperwork, that the HOA's lawyers were confident they'd prevail, and that he was recommending the board authorize additional legal fees, pulled from HOA dues, to fight the state's notice of violation. Then he opened the floor for questions, which I don't think he expected me to use, but I did. I stood up, introduced myself, and asked the room a simple question. Did anyone know that 6 ranching families downstream, families whose kids went to the same schools as theirs, whose beef some of them probably bought at the same farmer's market, had been rationing water for their livestock for over a month because of that beautiful water feature? Most of the room didn't know that. You could see it on their faces. I played about 90 seconds of the drone footage on my phone, passed around for people to see. I read out loud the flow numbers from Patricia Nguyen's report. I told them plainly that I had no interest in punishing 300 families for one board's decision, and that all any of us downstream wanted was our legal water flowing the way I had for 60 years. A woman near the back, a retired civil engineer, stood up and asked Marcus directly whether the HOA had actually obtained the required state dam permit before building the structure. Marcus hesitated a second too long, then said the county permit covered it. Elena, sitting beside me, said clearly enough for the room to hear, "It doesn't. There's no state stream alteration permit on file. That's a matter of public record." That was the moment the room turned. The vote. HOA bylaws in that community, like many, allowed for a special vote of the membership to override a board decision under certain conditions, especially regarding spending association funds on litigation not previously disclosed to homeowners. Within 2 weeks, enough signatures had been gathered to force exactly that kind of vote. I didn't organize that petition. I want to be honest about that. It was homeowners inside Aspen Ridge Estates, several of whom reached out to me afterward just to apologize for what their board had done and to ask, genuinely, how they could help fix it. That mattered to me more than almost anything else in this whole story. Most people, when they actually understand what's happening, want to do the right thing. The vote wasn't close. Homeowners rejected further legal spending to fight the state's violation notice, and a separate motion passed requiring the board to comply fully and immediately with Patricia Nguyen's order. Marcus Doyle resigned as board president 11 days later. I heard through the grapevine, take this with a grain of salt since I wasn't in the room, that several board members had grown uncomfortable with how confidently he'd assured them the county permit was sufficient, when it clearly wasn't, and how much of the community's trust and money that mistake had already cost. Chapter 9. The fence comes down. I was there the morning the construction crew arrived to remove the retention structure and reroute the flow back to its natural channel. So were 2 of the other downstream ranchers, and Patricia Nguyen from the state, there to inspect the restoration work. It took most of a day. Concrete piers pulled up, the small dam broken apart and hauled off, the diversion channel filled back in and reseeded with native grass at the state's direction to prevent erosion. The chain link fence itself stayed. That part was legal, since it was HOA property, and honestly I didn't mind, as long as it had a gate that respected our maintenance easement, which the new agreement required. I stood on the bank and watched the creek fill back in, watched the flow rate on my little gauge climb back toward what it should have been for that time of year. It's a strange thing, watching water come back. It doesn't rush or announce itself. It just quietly returns to doing what it's always done, like it was never really gone, just waiting for someone to stop getting in its way. The new HOA board, 3 new members elected at the same meeting Marcus resigned from, reached out to Elena's office within a month to formalize a written agreement, full acknowledgement of our senior water right, a permanent recorded easement clarifying maintenance access, and a commitment to consult a licensed water rights attorney before any future landscaping project near the creek corridor. They even invited me to a community meeting that fall, not as an adversary, but as a neighbor, to explain how water rights work out here, since apparently almost nobody in that development had known any of it before this happened. I went. I brought some photos of the creek from 1972, my father standing in it as a kid. People asked good questions. Nobody threw anything at me. What it cost, and what it was worth. I won't pretend this was free or easy. Between Elena's fees, the drone footage, the flow gauge equipment, and the hours I spent on this instead of running my ranch, I was out real money and time over those 5 months. The other ranching families chipped in for some of the legal costs once it became clear the outcome would protect all of us, which I was grateful for. But here's what I keep coming back to. That water right isn't just a line on an old piece of paper. It's the reason 6 families can keep cattle alive through a dry August. It's the reason hayfields that have fed this valley for 3 generations still turn green every spring. It's the reason a creek that's run through this land since long before any of us were born still gets to keep running the way it always has. A homeowners association board thought a 60-year-old certificate was just old paperwork standing between them and a nicer-looking pond. It turned out to be one of the strongest, most carefully protected legal frameworks in the American West, prior appropriation law, built specifically so whoever came first, and put the water to real, honest use, couldn't be pushed aside by whoever showed up later with a bigger checkbook and a fancier clubhouse. They found that out the hard way. The creek found its way back to where it belonged. And every spring since, when I walk that bank and hear it running full and cold over the same stones my great-grandfather once stood in, I think about how close we came to losing it, and how much a little patience, some careful documentation, and one very old piece of paper ended up being worth. What I learned about people. I want to slow down for a second before I wrap this up, because I think the easy version of this story is big corporation bad, rancher good, and that's not really what happened here. Most people who bought homes in Aspen Ridge Estates had no idea any of this was happening. They moved in for the good schools and the mountain view, paying their dues each month, trusting their board was making sensible decisions. When it turned out one man's confidence and a rushed landscaping decision had put their community on the wrong side of state law, most of them were embarrassed, not defensive. A handful drove out to my ranch that summer, unannounced, just to see the creek and apologize in person. One retired schoolteacher named Walter brought a six-pack of root beer and sat on my tailgate for an hour asking how water rights actually worked, because in 30 years of home ownership, nobody had ever explained it to him. That's the thing I keep coming back to. A lot of conflict like this doesn't happen because people are cruel. It happens because people don't know what they don't know, and because somebody in a position of authority makes a confident decision without doing the homework, and everyone downstream, literally in this case, lives with the consequences. I don't think Marcus Doyle woke up wanting to hurt 6 ranching families. I think he wanted a nice water feature for the marketing photos, assumed a county permit covered it, and dug in out of pride once challenged instead of checking the facts. Pride is expensive. It cost him his position, cost the HOA money in fines and legal fees they didn't need to pay, and nearly cost 6 families their summer water supply. The wider lesson. Since this all wrapped up, a few other ranchers in the valley have asked me to help them check their own old paperwork against the state's records. It turns out a surprising number of long-standing water rights out here have small clerical issues, an address never updated after a property transfer, an old owner's name still on file instead of the current one. None of that makes the underlying right less valid, but it can slow you down if you ever need to enforce it quickly, the way I did. Elena told me something that stuck with me. She said water law in the West exists precisely because water is the one resource nobody can manufacture more of, and the whole system only works if everyone respects the order in which rights were established, whether that's convenient for new development or not. It's not about who's rich or who's powerful. It's about who was here first, using the water honestly, and whether that use has been continuously maintained ever since. My family never stopped irrigating those hayfields for 63 years. That continuity is what made the certificate worth the paper it was printed on. I also learned how much good a little documentation habit does. That daily flow log felt tedious at the time. 5 minutes every morning with a gauge and a notebook. But it was that boring, unglamorous record that gave the state investigator hard numbers instead of my word against the HOA's word. My honest advice, start writing things down and taking dated photographs from day one, even before you're sure you'll need them. The creek today. The creek runs full now, the way it's supposed to. Last month I walked the same stretch where that fence used to stand, and if you didn't know to look for it, you'd never guess anything had ever been built there. The grass has grown back over where the concrete piers used to be. The new HOA board planted a small stand of willows along the bank as part of the restoration agreement, which I thought was a nice touch, even if I did tease them a little about it being their second attempt at landscaping that creek. My kids waded in it this summer. The same stretch of water their great-great-grandfather waded in back in the black and white photograph I keep on my office wall. The cattle drink from it without anyone rationing a drop. The 5 other ranching families downstream got their full allocation through the hottest part of August for the first time in over a year. None of that happened because I was louder or angrier than anyone at that HOA. It happened because 63 years ago, a stubborn man with a shovel and a piece of land filed the right paperwork with the right office, and because I was willing to spend a few months making sure that paperwork still meant something. Closing. If you made it this far, thank you for sticking with the whole story. If you've got water rights, easements, or old family agreements tucked away in a filing cabinet somewhere, do yourself a favor and get familiar with what they actually say, because you never know when a piece of paper from 1961 might turn out to be the most important document you own. Let me know in the comments if you've ever dealt with a boundary dispute, an HOA overreach, or a fight over something that should have belonged to your family all along. I read every one.